first talk about what happens if you file your ERISA claim in federal court and a concept called ERISA preemption. Most disability insurance policies are governed by the ERISA disability law, and that is a federal law, not a state law. Most disability insurance policies are issued through employers, not on the basis of buying your own individual disability policy. If you have purchased your own individual disability policy and your claim is denied, the difference is really crucial here because you have a contract with yourself and the insurance company to provide you the benefits. It's a contract. And if the individual disability claim is denied, you'll be bringing a claim in state law, not in a federal court. And so your rights under a breach of contract claim are broader than those under an ERISA claim. In a breach of contract case, you have the right to discovery, you have the right to jury trials, you have the right to claim not only what's owed you, but bad faith compensatory damages. Now, on the other hand, if your employer offered you a disability policy or plan, your claim is most likely governed by the ERISA Act. There are two exceptions. The first exception is if you work for a municipality or a state type agency. In other words, a governmental agency. That's probably a better way to put it. And the other exception is going to be if you work for an employer, such as the Catholic Church. A church plan is not covered under the ERISA statute. So those are two exceptions. Now, what's important about the Employer Retirement Income Act is that your remedies are extremely limited and you can only sue for back benefits. You might be awarded attorney's fees if you win and if the judge agrees that you're entitled to attorney's fees. The bad news is that an ERISA claim is most likely governed by something called the arbitrary and capricious standard of review. Now, most lawyers haven't heard of this, and it's not something that we're taught in law school. But the importance of the arbitrary and capricious standard of review is that it's unlike any burden of proof that you're familiar with. For example, in the criminal context, the state has to prove that you're guilty beyond a reasonable doubt. But in an ERISA case, it's a bit of the reverse. You have to prove that the decision that the carrier made denying your claim or the plan made denying your claim is what's called arbitrary and capricious. And I'll talk about that in a moment. But you need to understand that there is limited discovery and no right to a jury trial. So it's important that we understand this distinction. So why is that important? Because if you have a lawyer who doesn't understand that an ERISA claim is a federal claim, more often than not, what they'll do incorrectly is to file the claim in state court. And as a result, the carrier is going to file what's called a motion to remove your case from state court to federal court. And that's a lesson that I think is worth learning. And an example of that is the Felicia Patterson case. Now, Felicia was not represented by an attorney, and she made this mistake on her own. And she sued Hartford Life in a Dade County state court. Now, when she filed this lawsuit, the carrier, Hartford, filed a motion to remove the case to federal court. And she appealed saying, no, this should be in state court. Well, ultimately, this case went all the way up to the 11th Circuit in Atlanta. And the 11th Circuit said that her case had been properly removed under the preemption doctrine. Preemption means that when a federal statute displaces the state law, the case has to be filed in federal court. And so preemption is one of those legal concepts that lay people don't understand, and quite frankly, some lawyers don't understand. But ERISA is one of those statutes that preempts state law, and as a result, the claim has to be brought in federal court. Now, this wasn't the only mistake that Ms. Patterson made. The court dismissed her complaint, but allowed her to amend the complaint. But the court said, look, you have to plead exhaustion of remedies. What's exhaustion of remedies? You have to exhaust all your rights to appeal based on the appeal rights that you have in your disability policy or plan. And if you don't, the carrier can say, okay, they didn't exhaust their administrative remedies. Judge, you don't have jurisdiction. And what happens then is if there's 180 days in which to appeal, by the time you get through all this rigmarole with the court, I assure you that more than 180 days has passed. And so while she probably tried to file a pleading that explained that she'd exhausted her remedies, most likely she hadn't. And I suspect that the claim ultimately gets dismissed again. So you can see that there's a couple of mistakes that can be made by representing yourself or having a lawyer who's not experienced in handling an ERISA disability case. The first one is failing to complete or exhaust your administrative remedies by filing all the appeals. And the second is filing the lawsuit in the wrong court. You need to understand that the appeals process is crucial to any claim. You've got 180 days in which to file an appeal. And my appeals are anywhere from 25 to 65 pages long because the appeal is the trial of your case. So you don't want to delay in not properly and timely filing an appeal. And if your claim gets denied, of course, you need to file it in the right court or have a lawyer who knows what the right court is to file your lawsuit in.